Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Friday, August 19, 2022. It's about 2:15 or 2:20 in the afternoon. We've been covering this story for you involving the prosecutor of Hillsborough County, Florida. Normally, I wouldn't cover just a local political story, but this one has profound constitutional implications. This prosecutor, Andrew Warren, was popularly elected in Hillsborough County. That's the area around Tampa. In Florida, the prosecutors and the judges are elected at November elections. I come from a different tradition where the prosecutors and the judges are appointed by the governor and confirmed by the state senate. In the case of judges, if reappointed and reconfirmed before the end of 7 years, you have the appointment for life. Not so in Florida. Anyway, prosecutor, district attorney Warren is a liberal progressive. That's what the people of Tampa have chosen twice. And he decided he's not going to enforce Florida's abortion laws. The abortion laws prohibit all abortions after 15 weeks. There are some exceptions, but I don't need to get into them here. Once he made this announcement, but before he actually stopped enforcing, Governor DeSantis fired him and made a big sort of splashy, almost Donald Trump-like deal about it, holding up his signature on the order firing the prosecutor. Can the governor fire a prosecutor in Florida? The answer is yes, under very narrow circumstances. He can for incompetence and neglect. So the question is a judgment call made by a prosecutor not to prosecute a certain type of crime incompetence or neglect? Remember, this is not someone that Governor DeSantis appointed. This is someone the people elected. So you have principles of democracy at work here. Prosecutor Warren, District Attorney Warren, just filed a complaint in federal court, not in state court, in federal court. Very unusual to do that when there's a dispute with a state official over state law. It's rare to ask a federal judge to resolve this. But the prosecutor filed his complaint there. It's a profound, weighty, long complaint, which basically argues the governor didn't have any authority to do it. And because the prosecutor, he says, never made a decision not to prosecute people who perform or receive abortions after 15 weeks of the baby's gestation in the mother's womb, he was effectively being fired for speech, for words that he articulated when he expressed his own disagreement with Florida's abortion law. You guys know me. I'm pro-life. I believe the baby in the womb is a person from the moment of conception. However, the question is, did the governor have the authority to do this? Well, we don't know. I don't think he did. I think there are less effective ways for the governor to get the Florida abortion law enforced. He could have asked a prosecutor in a neighboring county to enforce it, or he could have appointed a special prosecutor just to enforce this type law, or he could have waited until the prosecutor actually decided not to enforce it. That has not yet come about. So there's no instance of somebody in this county wanting an abortion or having an abortion after 15 weeks and the prosecutor and his investigators learning of it and him deciding to look the other way. It hasn't happened. So a federal judge will resolve this. I can't predict which way it's going to go, but the prosecutor makes some very, very strong arguments under the Florida Constitution and under the First Amendment. More to come as we get it. Judge Napolitano for Judging Freedom.